In this part 44, as far as our lecture series is concerned, as I had told you in the past, we shall be dealing with chapter 39 as far as provisions regarding appeals are concerned. In case if a person feels that he is aggrieved by the decision which is given by the court of law after the trial is conducted by the court of law, which may result into conviction or acquittal. If accused person is convicted, he may feel that he is aggrieved by the decision which is given. If he is acquitted, the prosecution may feel that the prosecution is aggrieved by the decision which is given by the court. Even if the accused person is convicted, the prosecution may feel that the conviction which is imposed by the court of law is inadequate, and hence under such circumstances there is a provision that you go to the higher court in order to challenge the decision that is given by the lower court. And this is exactly what is known as appeal, which is nowhere defined in the criminal procedure code, but this is a provision of appeal. Now if you read the chapter, starts right from section 372 up to section 394 of the criminal procedure code, and the first section, section 372, makes it very clear: no appeal shall lie from any judgment or order of a criminal court except as provided for by this court or by any other law for the time being in force. It does mean that appeal is not a fundamental right. Appeal is not inherent power. Appeal, you can prefer an appeal provided it is provided by the provisions of the criminal procedure code or any other law for the time being in force, maybe as far as this chapter of the criminal procedure code is concerned or any other part. For example, this is the time for you to refresh your memory as far as section 86 of the criminal procedure code is concerned, where if the application is made for restoration of the property and if it is rejected, a person has got right to prefer an appeal. Or during course of time, when we shall be dealing with section 449, namely when we shall be dealing right from section 436 up to 450 is the chapter which deals with provision regarding bail and bonds. When the order is passed by the court of law as per section 446, you can prefer an appeal as per section 449 of the criminal procedure code is concerned. Or when we shall be dealing with disposal of property right from section 451 up to section 459, and if the order is passed maybe as per section 452 or 453, and if anybody feels that he is aggrieved by the order that is passed by the court of law, he can prefer an appeal as far as section 454 is concerned. This is, I say, enumerative and not exhaustive list. So you may come across provisions as far as appeal is concerned, and then you are guided by this chapter right from section 372 up to section 372 up to 394, dealing with provision regarding appeals. And subclause 1 with which we start, subclause 1 or the section with which we started clearly lays down: no appeal shall lie from any judgment or order of a criminal court except as provided for by this court or by any other law for the time being in force. This is also the time for me to draw your attention to the provisions of the constitutional law and refer to Article 132, Article 134, Article 134A and Article 136 of the Constitution of India is concerned, where you come across provision regarding appeal. Now the further part of the section makes it very clear, and it says, provided that the victim shall have a right to prefer an appeal against any order passed by the court acquitting the accused or convicting for a lesser offence or imposing inadequate compensation, and such appeal shall lie to the court to which an appeal ordinarily lies against the order of conviction of such court. So that is as far as section 372 is concerned. Now, as far as section 373 is concerned, it says appeal from orders requiring security or refusal to accept or rejecting surety for keeping the peace or good behavior. Now this has got reference to right from section 106 up to 124 with which you are dealt, and section says any person who has been ordered under section 117 to give security for keeping the peace or for good behavior, or who is aggrieved by any order refusing to accept or rejecting the surety under section 121 may appeal against such order to the court of session. Now this is the power that vests to pass an order, is the power that vests as far as the executive magistrate is concerned. But this section 373 says, well, may appeal against such order to the court of session. So it is to the court of session, provided that nothing in this section shall apply to persons the proceedings against whom are laid before a session judge in accordance with the provisions of subsection 2 or subsection 4 of section 122. With this now, as we go on learning this chapter as far as provision regarding appeals are concerned, when the appeal shall lie against conviction, for that I mean you have to read section 374, section 379 and section 380. There are some sections where there is no provision of appeal, with which we shall be dealing by taking into consideration two sections, namely section 375 and section 376 as far as this chapter is concerned. Section 377 deals with the cases where the punishment that is imposed by the court of law, if prosecution feels that it is inadequate for enhancement of the punishment, there is a provision of appeal as far as section 377 is concerned. Whereas section 378 lays down the procedure. When the order is that of an acquittal, what is the procedure or where the appeal shall lie is made very clear as far as section 378 of the Criminal Procedure Code is concerned. And rest of the part of the chapter with which we shall be dealing, what is the procedure that is required to be followed as far as the appeal is concerned. And then what do you mean by appeal is summarily dismissed? If it is not summarily dismissed, there is a regular hearing of the appeal, and what are the powers of the appellate court, with which we shall be dealing by taking into consideration section 386, section 389, section 390 and section 391 of the Criminal Procedure Code. And then the section, what happens when, is there any provision as far as abatement of appeal, with which we shall be dealing as far as section 394 of the Criminal Procedure Code is concerned. So with this we start with section 374, which says appeals from convictions, and it says any person convicted on a trial held by High Court in its extraordinary original criminal jurisdiction may appeal to the Supreme Court. Subclause 2 says any person convicted on a trial held by a session judge or an additional session judge, or on a trial held by any other court in which a sentence of imprisonment of more than 7 years has been passed against him or against any other person convicted at the same trial may appeal to the High Court. And subclause 3 says as otherwise provided in subsection 2, any person convicted on a trial held by a metropolitan magistrate or assistant session judge or magistrate of the first class or of the second class, or sentenced under section 325, or in respect of whom an order has been made, or a sentence has been passed under section 360 by any magistrate may appeal to the court of session. That is as far as section appeal from conviction as dealt by section 374 of the Criminal Procedure Code. With this now, if we come to section 379, which says appeal against conviction by High Court in certain cases. And it says, where the High Court has on appeal reversed an order of acquittal of an accused person and convicted him and sentenced him to death or to imprisonment for life or to imprisonment for a term of 10 years or more, he may appeal to the Supreme Court as far as section 379 is concerned. Whereas, if you read section 380, it lays down special rights of appeal in certain cases. And it says, notwithstanding anything contained in this chapter, when more persons than one are convicted in one trial and an appealable judgment or order has been passed in respect of any such persons, all or any of the persons convicted at such trial shall have a right of appeal. So that is as far as section 380 of the Criminal Procedure Code is concerned. With this now, we shall be dealing with two sections, namely where there is no provision of appeal. And section 375 and 376 are the sections with which we shall be dealing. Section 375 says, no appeal in certain cases where accused pleads guilty. And it says, notwithstanding anything contained in section 374, where an accused person has pleaded guilty and has been convicted on such plea, there shall be no appeal if the conviction is by a High Court, or if the conviction is by a court of session or metropolitan magistrate or magistrate of the first class or second, except as to the extent or legality of the sentence. So that is as far as section 375 is concerned. Section 376 says, no appeal in petty cases. And it says, notwithstanding anything contained in section 374, there shall be no appeal by a convicted person in any one of the following cases, namely, which is the question of enumeration. Small a says, where a High Court passes only a sentence of imprisonment for a term not exceeding 6 months, or of fine not exceeding 1,000 rupees, or of both such imprisonment and fine. Small b says, where a court of session or metropolitan magistrate passes only a sentence of imprisonment for a term not exceeding 3 months, or of fine not exceeding 200 rupees, or both such imprisonment and fine. And subclause c says, where a magistrate of the first class passes only a sentence of fine not exceeding 100 rupees, or subclause d says, where in a case tried summarily, a magistrate empowered to act under section 260 passes only a sentence of fine not exceeding 200 rupees. So these are four categories which are enumerated as far as section 376 is concerned, where no appeal shall lie, provided that an appeal may be brought against any of such sentence if any other punishment is combined with it, but such sentence shall not be appealable merely on the ground: 1. That person convicted is ordered to furnish security to keep the peace, or that a direction for imprisonment in default of payment of fine is included in a sentence, or that more than one sentence of fine is imposed in a case if the total amount of the fine imposed does not exceed the amount hereinbefore specified in respect of the case. So this is as far as section 376 is concerned. Now section 377 deals with the cases where appeal by the state government against sentence. And it says, save as otherwise provided in subsection 2, the state government may, in any case of conviction on a trial held by any court other than a High Court, direct the public prosecutor to present an appeal against the sentence on the ground of its inadequacy to the court of session if the sentence is passed by the magistrate, to the High Court if the sentence is passed by any other court. Subclause 2 says, if such conviction is in a case in which the offence has been investigated by Delhi Special Police Establishment constituted under the Special Police Establishment Act of 1946, or by any other agency empowered to make investigation into an offence under any central acts other than this code, the central government may also direct the public prosecutor to present an appeal against the sentence on the ground of its inadequacy to the Court of Session if the sentence is passed by the magistrate, to the High Court if the sentence is passed by the other court. Subclause 3 says, where an appeal has been filed against the sentence on the ground of its inadequacy, the Court of Session, or as the case may be the High Court, shall not enhance the sentence except after giving to the accuser reasonable opportunity of showing cause against such enhancement. While showing cause, the accused may plead for his acquittal or for the reduction of sentence. With this now, Section 378 of this chapter lays down procedure regarding appeal in case of acquittal, and it says, save as otherwise provided in subsection 2 and subject to the provisions of subsection 3 and 5, the district magistrate may, in a case, direct the public prosecutor to present an appeal to the Court of Session from an order of acquittal passed by a magistrate in respect of cognizable and non-bailable offence. B. The state government may, in any case, direct the public prosecutor to present an appeal to the High Court from an original or appellate order of an acquittal passed by any court other than a High Court, not being an order under subclause A or an order of acquittal passed by a Court of Session in revision. Subclause 2 says, if such an order of acquittal is passed in any case in which the offence has been investigated by a Delhi Special Police Establishment constituted under the Delhi Special Police Establishment Act of 1946, or by any other agency empowered to make investigation into an offence under the Central Act other than this code, the central government may, subject to the provision of subsection 3, also direct the public prosecutor to present an appeal to the Court of Session from an order of acquittal passed by a magistrate in respect of cognizable and non-bailable offence, to the High Court from an original or appellate order of an acquittal passed by any court other than a High Court, not being an order under clause small a or an order of acquittal passed by a Court of Session in revision. Subclause 3 says, no appeal or the High Court under subsection 1 or subsection 2 shall be entertained except with the leave of the High Court. Subclause 4 says, if such an order of acquittal is passed in any case instituted upon complaint, and the High Court on an application made to it by complainant in this behalf grants special leave to appeal from the order of acquittal, the complainant may present such appeal to the High Court. Subclause 5 says, no application under subsection 4 for the grant of special leave to appeal from an order of acquittal shall be entertained by the High Court after the expiry of 6 months, where the complainant is a public servant, and 60 days in every other case computed from the date of that order of acquittal. And subclause 6 says, if in any case the application under subsection 4 for the grant of special leave to appeal from an order of acquittal is refused, no appeal from that order of acquittal shall lie under subsection 1 or under subsection 2. With this now, whenever there is appeal to the Court of Session, what is the procedure and how it is heard is dealt as per section 381 is concerned, which says appeal to the Court of Session, how heard. And it says, subject to the provisions of subsection 2, an appeal to the Court of Session or Session Judge shall be heard by Session Judge or by an additional Session Judge, provided that an appeal against a conviction on a trial held by a magistrate of the second class may be heard and disposed of by an assistant Session Judge or Chief Judicial Magistrate. Subclause 2 says an additional session judge, assistant session judge, or a chief judicial magistrate shall hear only such appeals as the session judge of the division may, by general or special order, make over to him, or as the High Court may, by special order, direct him to hear. Now, whenever the appeal is required to be preferred, what is the manner in which it is required to be preferred is dealt as far as section 382 is concerned, which says, every appeal shall be made in the form of a petition in writing presented by applicant or presented by appellant or his pleader, and every such petition, unless the court to which it is presented otherwise direct, be accompanied by a copy of judgment or order appealed against. And then what happens in a case where the appellant is in jail is made very clear as far as section 383 is concerned, which says, if the appellant is in jail, he may present his petition of appeal and the copies accompanying the same to the officer in charge of the jail, who shall thereupon forward such petition and copies to the proper appellate court. Now, the next stage, once the appeal is preferred, there is a provision of summary dismissal of appeal as far as section 384 is concerned. It says, upon examining the petition of appeal and a copy of judgment received under section 382 or section 383, the appellate court considers that there is no sufficient ground for interfering, it may dismiss the appeal summarily, provided that no appeal presented under section 382 shall be dismissed unless the appellant or his pleader has had a reasonable opportunity of being heard in support of the same. And clause B says, no appeal presented under section 383 shall be dismissed except after giving the appellant a reasonable opportunity of being heard in support of the same, unless the appellate court considers that the appeal is frivolous or that the prosecution of the accused in custody before the court would involve such inconvenience as would be disproportionate in the circumstances of the case. And clause C says, no appeal presented under section 383 shall be dismissed summarily until the period allowed for preferring such appeal has expired. Subclause 2 says, before dismissing an appeal under this section, the court may call for the record of the case. Subclause 5.3 says, where the appellate court dismissing an appeal under this section is a court of session or of a chief judicial magistrate, it shall record its reasons for doing so. Subclause 4 says, where an appeal presented under section 383 has been dismissed summarily under this section and the appellate court finds that another petition of appeal duly presented under section 382 on behalf of the same appellant has not been considered by it, that court may, notwithstanding anything contained in section 393, it satisfied that it is necessary in the interest of the justice so to do, hear and dispose of such appeal in accordance with law. If it is not summarily dismissed, then section 385 says, procedure for hearing appeals not dismissed summarily. And it says, if the appellate court does not dismiss the appeal summarily, it shall cause notice of the time and place at which such appeal will be heard to be given to the appellant or his pleader, to such officer as the state government may appoint in this behalf, if the appeal in the form if the appeal is from a judgment of conviction in a case instituted upon complaint to the complainant, if the appeal is under section 377 or section 378 to the accused, and shall also furnish such officer, complainant and accused with a copy of grounds of appeal. Subclause 2 says, the appellate court shall then send for the record of the case if such record is not already available in that court, and to hear the parties, provided that if the appeal is only as to the extent or the legality of the sentence, the court may dispose of the appeal without sending for the record. Subclause 3 says, where the only ground for appeal from a conviction is the alleged severity of sentence, the appellate shall not, except with the leave of the court, urge or be heard in support of any other ground. With this now, as we have dealt with the procedure for hearing appeals not dismissed summarily, now we want to take into consideration what are the powers of the appellate court. And in order to know the powers of the appellate court, we have to deal right from section 386 onwards, namely section 386, section 389, section 390 and 391, and the rest of the part as far as this chapter is concerned, with which we will continue our discussion as far as our next lecture is concerned.